Welcome to the I Got Fired show for people who have been fired or afraid that they might be. I'm Tom Spiggle, host of the show and founder of the Spiggle Law Firm. We are thrilled to have with us today our own Winthrop Hubbard, which if you watch the other two episodes, you know that he works as an attorney in our office and formerly worked at the EEOC. So can give us a behind the scenes look at what it is like to work at what that very important agency is like, which is obviously a crucial agency for anyone attempting to realize their rights, their employment law rights, individual employment law rights. So we are today going to go through the top 10 mistakes that people make when trying to file with the EEOC. So with that, I'm going to turn it over to Winthrop for our first number one mistake.
Absolutely. And the first one is a pretty simple one, but it's also probably the most important one, which is failing to file a charge at all with the EEOC. As we've talked about on our past shows, this agency, the Equal Employment Opportunity Commission, or its local affiliates, is a necessary step. You have to take it if you're going to file a lawsuit based on employment discrimination or something related to that. So you have to file. It's either going to be within 300 or 180 days, and it's a totally understandable mistake because it's not intuitive. There's no reason that people would think that they would have to file a charge with a government agency before they can get the remedies that they think they deserve because of the discrimination they've faced. So first biggest mistake, file with the EEOC. And Tom, I think, is going to talk about in the number two ways that you can think you filed but maybe haven't. So I think that the first major thing you got to do is file with the EEOC.
Yeah, that's absolutely right. And then number two, failing to complete the filing process. And by that, we mean you have to file what's called a Form 5 for it to have actually effectuated or actually filed a charge. Anything before that is not actually filing a charge, which is what you need to do to stop the clock on the statute of limitations. This either 180 days or 300 days that we've been talking about. There have been some unfortunate cases where people have gone to the EEOC and completed an intake process where intake notes are taken, but they don't actually, and they mistakenly believe they have filed a charge with the EEOC, only to find out that they didn't complete it because the Form 5 was not completed. And Winthrop, you can give us some detail on this, but generally the way it happens is if you go in on your own, there will be an intake interview with one of these specialists there, and then they will take those notes and usually either on the spot or later send you a Form 5, which you have to sign, and then that is filed. That's my understanding. Is that how you did it when you were there, Winthrop?
Yep, and sometimes what would happen is people would send in a questionnaire that they've completed online or gotten access to through a call center, they've called in and then they've been sent the questionnaire. And then they would not, and then we would follow up and call them, and that would be one of the things we did. And then after that call, we'd have them do a Form 5, write up a Form 5, or we'd write one up for them and send it to them for their signature. So yeah, anything less, and it says Form 5 on the piece of paper, so you'll know what it is. And it looks formal. It's not a question and answer form. It's a information and then box at the bottom where you fill in what has happened and why you believe you've been discriminated against. So if you fill out a question and answer form, that's not a Form 5. Or if you go to the EEOC and they don't give you a Form 5 for you to sign, you haven't filed a charge. If you go to, this is the only way to file a Form 5 is to file a Form 5, and it's absolutely the necessary part of the process.
Right. That's right.
So yeah, I think that's two.
That's two, and I'll turn you over to number three, which is failing to check all the appropriate boxes on the Form 5.
Right. One of the things you'll see on the Form 5 is all of the possible forms of discrimination that the EEOC protects against. And so you want to make sure that when you file your Form 5, you check all of the ones that apply to you. This can include one that is often misunderstood, which is retaliation, which is you have in some way participated or in some way complained of discrimination against protected classes and are now action is being taken against you because of that. So don't forget to check that box if you think it's relevant to you. The reason that this is so important is for the same reasons that the Form 5 is important, which is it controls what you have brought to the EEOC. So if you file this Form 5 and you don't check all the boxes, you haven't filed with the EEOC for those types of discrimination, which means you then can't bring a lawsuit based on those types of discrimination if the EEOC process doesn't end your case. So it's very important that you check all the boxes, because those little boxes are going to control what the EEOC investigates, and what the EEOC investigates is going to control what you can then file a lawsuit on.
Yeah, it's like building the foundation of a house. You got to have that foundation there before you can't add other rooms to the top if you don't have the proper foundation. All right, I'll let you introduce what I think is our fourth one, which is...
You got the fourth.
Huh? Yeah, I'm doing the fourth.
You got the fourth one.
Failure to, that's right. All right, number 4, which is failure to update the Form 5. And so what this means is that after you file the Form 5, if other things happen to you, or if you didn't, allege all the things that you needed to in the Form 5, if you don't update your Form 5 correctly, you may lose your ability to bring those to file a charge or bring a claim based on those things that have happened. There have been 2 examples that I've seen of this, really unfortunate ones. There were them in court cases on. And what seems to have happened is that somebody went to the EEOC and filed a charge on their own, which is great. For folks who can't find a lawyer or want to do their on their own, we recommend that. Then they went and hired a lawyer, and the lawyer interviewed them and realized there were other potential claims, retaliation or otherwise. And what the lawyer did is he or she then wrote a letter, which is not uncommon, but wrote a letter to the opposing party, to the company, and said, hey, all this bad stuff happened to my client. But then this lawyer did not update the Form 5, did not file an amended Form 5, to formalize that charge. And the courts, got all the way up to the courts, and the court said, sorry, employee, you have to, the EEOC process is there for a reason. You have to put the employer on notice through the Form 5, and sending a written letter outside of the EEOC process, even if you can show that the other side got it, is not sufficient to protect those claims. So just remember, and there's nothing wrong with sending the letter. That's not a bad idea. It can certainly help with settlement, but in order to preserve your claims, you got to make sure that all the claims that you included in that follow-up letter are included in your revised Form 5. Anything else that you want to add to that, Winthrop?
Yeah, just going back one more time to the retaliation thing. One of the things that could happen is that you file a Form 5 while you're still employed with with the person that you're filing the Form 5 against. Your retaliation covers if your employer sees that Form 5 come to them and takes action against you, retaliates against you because you filed that charge. So it's important that if that happens, if you're still employed, you file a charge and your employer retaliates against you, that you amend your charge to update it with the ongoing retaliation that you've been facing. And then you check that box for retaliation on the amended charges, because that action is part of what the EEOC will look at, and it's often the case that employers don't necessarily respond well, even though they should, to having a Form 5 charge filed against them.
Absolutely. All right, and then we're on to number 5. What's that one, Winthrop? I think you're up.
That one is you should not take what the intake person tells you as gospel, which, as a former intake person, I can tell you is a good plan, because they may not know everything, and they may not know the law down pat. They may not know everything about your situation. Obviously, there's a limited time period in which you're engaging with them, and so they may not know what they say is not necessarily going to control. These people are oftentimes not lawyers. They can even be, while I was there, I was a law student, so it was in my summer, so they can be law students. And they can be wrong. They can be wrong about the process. So you shouldn't take what they say as gospel. You should follow through with what you think, cover your bases. That's not to say you shouldn't listen to what they're saying and consider it, but you should definitely, if you're concerned that following their advice would lose your ability to file a charge in some way, go through with filing a charge, and they'll understand. Hopefully they'll be understanding about that, and it's your charge. They have to listen to what you say. So don't take what they say as gospel. Make sure that your bases are covered.
Yeah, absolutely. We had a case, in fact, last year where they brought what I thought was a particularly strong pregnancy discrimination case to the EEOC. And the intake person, a young woman, told her that she didn't think that this was a strong claim. Unfortunately, this woman was actually an attorney and said, I disagree, and then went ahead and filed the Form 5. And they came to me, and it was actually one of the strongest claims I had ever seen. And so the fact that this intake person had said that was really a little shocking. So, absolutely, a lot of really educated folks there. You should, certainly listen to what they say, but don't take it as gospel. And another thing is, you and I were discussing earlier before we got on the show, is that you can't even trust completely the EEOC's electronic filing system. For instance, you and I had a case, Winthrop, where we were trying to file the charge online and it would not let you file. Is that right? It was you? Okay. And then because it said, it was not you.
It was me.
Oh, it was somebody else in the office that they.
It was me.
It was you.
It was
right.
me.
Okay, well, why don't you go ahead and tell that story?
Yeah.
What happened?
So it was in the state of Virginia, and it was like we mentioned briefly, I think earlier. There's deadlines in which you have to file the charge by. It's either 180 days or 300 days, depending on whether or not the jurisdiction you're filing a charge in has its own laws that protect employees and its own agencies. Virginia does, but for some reason, the EEOC website thinks that they don't, which means that it thinks that you only have 180 days to file in Virginia, which is not true. You have 300 days to file within the entire state of Virginia an EEOC charge. And the website, I was trying to file after the 180 days, but before the 300 days, and it was trying to tell me that I was outside the time range and that the charge would be rejected. So, or not rejected, I think it prevented me from filing, which is strange to begin with, because it should just allow you to file either anyway, and they can toss it out.
Yeah.
But anyway, it was preventing me from filing online, and that was incorrect. It was incorrect, and we had to file in person, I believe, or we mailed it or something, or I think we faxed it in actually. But the point being, if you're not sure, if you think that they're wrong, do it anyway. Find another way.
Absolutely right. Another point about that is we were lucky enough to be close to close to the EEOC office, and sorry for bringing the phone here, close to the EEOC office. And so you were able to, I guess you faxed it in, so you could fax from anywhere. But, it could be a problem for somebody who's up against the 180 days or the 300 days, and maybe they don't have access to a fax and they're not close enough to the office. So that's another good, lesson, is to give yourself a couple of days cushion at least, because, Murphy is well alive in any kind of filing process. And if it can go wrong, it will. So another reason to not take the EEOC, even their website, as gospel. All right, I think we were on to number 6, which is I'm up, which is failing to go to mediation. The EEOC mediation is not mandatory; it is discretionary, and so you can, if you want, if the EEOC comes to you and says, "Hey, would you like to come to mediation?" You can say, "No, thanks. I'd like for this to go into investigation." That's a big mistake. If the employer is willing to mediate, then you should go too, if only because it's free discovery for you. And by that, I mean, it's maybe the first time that you get to sit down across the table from the lawyer for the company and a representative from the company and hear firsthand what the other side's going to say. Because unless they've offered to settle with you at this point, they've got some kind of defense, they think, to your claim. And this is a good opportunity to go and listen to it and see what they say. You always get more detail than you do just by written correspondence. If nothing else, you get to see what their attorney is like. And they may bring somebody who has authority to settle on behalf of the company that's not somebody that maybe it's somebody senior in the HR department. It might be, if they have an insurance policy, it might be their adjuster. So you get to speak to them, and if you have an attorney, the attorney can speak to them across the table. And so you get that bit of free discovery, even if the actual mediation is unsuccessful. But the second reason is sometimes mediation is successful. and you can
Right.
go and by virtue of the fact that you are, across the table from somebody. And remember, if the employer comes, then they're there to listen too. And sometimes they won't settle until they've had a chance to actually see you and see if they believe you. Because a lot of times the attorney is not somebody with the company, is not somebody that's going to have any direct experience with you. But if they get there and you are believable and you make an impassioned case for yourself, or your attorney does, or both of you do, then you might move the needle and get the employer to, to actually get the case settled. But because it is discretionary, it is possible to say that you don't want to do it, and that generally is a mistake. So go to get the free discovery, even if you don't settle, and who knows, you might actually settle. Just an aside tip about the mediation. If you've got a lawyer, you should be doing this through him or her. But if you were dealing with the other side yourself, which a lot of people do when they're filing what we call pro se or without an attorney at the EEOC process, is make sure that company is going to bring somebody with settlement authority. Now, the EEOC is supposed to do that on their own. It's supposed to make sure that happens, but a lot of times that does not get communicated well. And I've gone to mediations before where they bring some sad sack to mediation who's like, well, I've got authority to settle for $500. I can't settle for anything other than that. And we have to try to get somebody on the phone, and it's a waste of everybody's time. So, the best practice is to confirm yourself, either through the mediator, if you can get him or her on the phone, or by dealing directly, either through your attorney or with the employer itself to make sure they're going to bring somebody with settlement authority. And then it's also best practices. It doesn't always happen, but if you can get at least some settlement offer on the table, even if it's a low ball from the other side, just say, hey, you just be candid with them. These mediations are much more successful when there's some numbers on the table. So, you've proposed a number, ask them to propose a number back. Now they may not do that, and that may not be successful, but you might get them to actually put something on the table. And I've just found that just breaking the ice in that very small way makes it much more likely that you're going to get a settlement through the mediation. So, but yes, number 6, failing to go to mediation is a big mistake. I think you're up for number 7.
Yeah,
right?
a couple things on that too.
Yeah, sure.
Hold on. Sure, but back on number 6, a couple things is the EEOC will be providing the mediator, so it will be a good neutral party that
Yep.
you can talk to, and they will go back and forth with. So that's good as well. It's a free mediation, of course. I think we mentioned that earlier, which is it's nowhere else. Like it doesn't exist.
Yep.
Another thing is some local agencies, if you file with the local agency instead of the federal EEOC, will have mandatory mediation, which can be good or bad because it means that the employer has to go through the process. It means they're there not necessarily of their own choice, but because the law says they have to be, which means they might not actually be any authority to settle or any of the things we talked about earlier. It could be a little bit of a waste of time, but they do have to be there. So it could be a reason to think about filing with one of the local agencies. I know that for instance, the DC Office of Human Rights requires mediation from both parties. The other thing is it's really fast. The best part about mediation at the EEOC is it's the first thing they're going to ask you when you're filing your charge. They're going to say, here's your charge to file, sign this for us. Also, here's this mediation form saying, hey, are you okay? Will you approve mediation? Or are you willing to try it? And you'll sign that one, and they'll send a similar form to your employer or former employer, and then they will, along with your charge, and then they'll sign that and send that back. And it's very quick. And time is important in these situations. The EEOC process is long. And if you can settle it through the mediation process, you can save yourself what is oftentimes years of pain, stress, and lack of income. So the mediation process is really, if you can get them across the table from you and you can figure this out quickly, it's a gift, really.
Yeah, no question.
So then number 7. Failing to reply to the EEOC during the investigation process. So one of the things that's going to happen is you file your charge, they send your charge to the employer. The employer is going to send back what is likely, in a lot of cases, a long response filled with exhibits and every little thing that you've ever done wrong, or every little thing that they can say you've done wrong, or every little thing they can make up about you doing wrong. And that's going to be the statement from the employer. And when that happens, a lot of times the EEOC isn't going to know the details of your situation. They've listened to you. The person investigating it may not even be the person who did your intake. Oftentimes that is the case. So they don't know you. They don't know your credibility. They don't know anything except what you've written in your charge and what the employer has said in response. And so they're going to come to you likely, and they're going to say, here's what your employer said, rebut this. And absolutely essential that you try to do that. Obviously, it's a lot easier if you have an attorney, but even if you don't, try to go through your records and provide whatever information you can from your memory and from whatever physical documents you have, whatever emails you have that can rebut the story that the employer is putting forward, because that's all the EEOC has to work on. So if you don't rebut the employer's allegations, your charge is going to get dismissed, which is not necessarily the worst thing, but the more you can get out of the EEOC process, the more free discovery you can get, the more time, the more information you can get about what the employer thinks, the better. So make sure that you respond, and if you can get a for cause, which means if you can get the EEOC to agree that you were terminated for cause, you can get access to some really good options. So the best thing you can do is to do everything in your power to work hard, meet the deadline the EEOC investigator gives you on the response, and put together a nice, solid response that demonstrates you have your stuff together, and you are correct in this, and that their allegations against you are what we call pretext. So I think that's the best way. One of the biggest mistakes people can make is not taking that response seriously, because that's all the EEOC knows about you.
Or missing it completely. I mean, that's one of the difficult things about dealing with any administrative agency, but particularly with the EEOC, is there can be months, in rare cases, there can be over a year of silence from the EEOC while your case is kind of getting shuttled about and they do whatever minimal investigation they're going to do. So, it's entirely possible you hear crickets for them for 3 months, and then all of a sudden, and they probably won't call. It's going to show up in your email inbox, and they might mail it. They probably will mail it, but it's going to show up in your email inbox that says, hey, like you said, this is what your employer is alleging. This is what we need you to respond to. And sometimes they can give you a very short turnaround time. We need to know in 2 weeks what your response is to these allegations. Now, I can say you can often get an extension for that. So, if you open the email on day, 13, and you're like, there's no way I can get a response by day 14.
Ask for an extension.
Yeah, you can email them and say, I want to respond to this, but I need an extra couple of weeks, and they usually will give that to you. But so that's another important point to remember too, is that it's sort of very spotty when you're going to hear from the EEOC, and the irony is you may be trying to call your investigator and calling the EEOC, and they may not be returning your calls. That's not uncommon too. So it is what it is. It doesn't hurt to stay in contact with your investigator, just to check in every now and then and say, hey, I haven't heard anything. Do you need anything from me? But absolutely, when that email shows up, you want to make sure not to ignore it, because it's an easy way for an overworked EEOC staffer to bounce another case off their desk and perhaps deny you an opportunity a rare opportunity, but an opportunity nevertheless to get a for-cause finding and have the EEOC take the case on your behalf. All right, I think, what am we on, number 7? I think we're on number 7, which is the number 7 mistake is is this number 7 or number 8?
Number 8.
Number 8. All right. I can't do my counting here. Number 8, being a jerk to the intake personnel. Obviously people who have been fired or are going through this process are under a lot of stress. If you go down to file the charge yourself, you may wait for hours in, a sterile government lobby. If you're on the phone, you can easily wait for hours. And if you don't have a good book to read, then and you haven't gotten your cup of coffee by the end of it, you can be in very short, have a very short fuse. And so there is a temptation among some to be a jerk or to give a hard time to the intake personnel. Everything from the secretary that you meet when you come into the office. And I'll say this is true for any kind of legal environment, particularly dealing with judges. But let's talk about the EEOC. Is assuming that the people you're dealing with are just low-level flunkies and that therefore if you tee off on them, it's not going to affect your case. And the truth is, in very rare exceptions, the folks at the EEOC are not going to purposefully scuttle your case just because you are rude to them. But, they're people too, and they do, whether consciously or unconsciously, they can kind of put their thumb on the scale one way or another. And they've got to often write up a report that will go to the attorney who's going to be investigating it, or whoever, their upper, the person that's going to be supervising the process, and how they describe you and your, for example, and how they describe you is going to matter. And if here's the other thing, if your employer writes back in their defense and they say, well, we fired him not because we were, we didn't like men or because we were racist, it's because he was rude. Well, if you show up in the intake process and you're rude, what do you think that does to your case? It doesn't, it can confirm what the employer is saying about you, even if that is in fact untrue. So remember, everybody that you're dealing with the EEOC is a person. You going back to our earlier number, you don't want to take what they say as gospel, but you want to treat them in a polite way. I think I mentioned in one of our other shows that we got a file, because you can FOIA, for Freedom of Information Act. You can file one of those requests when your case is done to get your file to see everything in it in the EEOC. And in this one, the investigator had some fairly negative things to say about the person who was our client who would come in to file a charge. So remember that's going to end up in a report somewhere, and you should try to prevent that. You want them to say good things about you.
Right. And even more than that, this is an office environment that these people are in. So, if you're rude to the receptionist, you better believe she's going to go down, and he's going to go down and talk to their investigator friends. Can you believe what this person said to me? And the same thing is true of the person you do your intake with. Even if they're not your investigator, they're writing up the initial report on you. They have an internal filing system, and it's a lot more work for the investigator to prove wrong the initial impressions of the first person you talk to in the door. And like we've said over and over again about the EEOC, they are overworked. And if you want them to, spend the time they should be spending on your case, the best thing you can do is make a good impression. And that's not to say that these people are always going to treat you in the nicest way possible. They could be dismissive, they could be curt, they could want to toss you out the door the minute you step in the room. But if you can just try to maintain your composure in what is, we understand, and most of the employees at the EEOC will also understand, is an intensely emotional situation. So yeah, Tom, I think you hit it right perfectly. Yeah. Just be as civil as possible. These are people too.
And dress nicely. And little things matter. And I think you do what you can, right? Like if it's day 299, I don't care if you show up in your underwear, a little bit of hyperbole, but you got to get that thing filed, right? You don't want to lose your right to sue. But if you got a little bit of time, dress up, put your best foot forward. Again, this is not something that the investigator is going to be looking at specifically, or the intake person is going to be looking at specifically. But you better bet if you come in, and a nice pair of slacks and a tie, they're going to take you more seriously than if you come in with your wife beater T-shirt and looking less than professional. So again, it's right. Not a court hearing. They're not going to videotape it. It's none of that. But nevertheless, these are people. They make snap judgments like we all do. So if you're going to go down in person, dress up a little bit, look nice.
Right. Okay. Number 9.
Yes. Number 9.
All right. Number 9 is what happens when, so basically as a quick intro, most of cases, almost all the cases that go to the EEOC, leave the EEOC with what's called a notice of right to sue. And in that notice of right to sue, it's going to say you have 90 days after that has been issued, not when you get it, after that has been issued, to file a lawsuit on these issues, or you will, similar to if you don't file a charge at all, you will lose access to these rights, to your right to file a suit on these cases. So, big mistake again, kind of similar to the very beginning of the podcast. Do not miss that deadline. It's a short deadline, and like we've been saying earlier, It can come out of the blue. You may not know it's coming. It's going to show up. It's going to show up in your mailbox and probably your email box, but definitely your mailbox. And if you miss it, if you miss that 90 days, you are out of luck. There is no backup. That is it. And it's a short time period, and you've got a lot to do in that time period. If you don't have a lawyer already, you've got to decide if you want to hire a lawyer. And because now we're going into the court process, and there's a lot less help for pro se litigants there than there is at the EEOC. So you've got to figure out if you want to hire a lawyer. You got to figure out if you can, if you want to file this suit at all, or what your options are. And you've got to make some financial decisions, and you got to make some financial calculations. And you have really less than 90 days because you're not going to get it the day you're probably not going to get it the first day that they make the determination. So it's a stressful time period, but do not miss that 90-day time window. Otherwise, you will lose access to these claims, and by which we mean there will be no more remedies available for you on these issues.
Yeah, that's absolutely right, which is another good, you want to make sure that the EEOC has your correct mailing address. So if your case has been going on for a year or more and you move, you want to make sure that you send them a letter knowing what your new mailing address is, because they're going to send it to the address that they have on file. Which brings me to one point there, there is a little bit of wiggle room if they send it to the wrong address. Right. And, courts are, they vary a little bit on this. And I should say, everybody should take this as legal advice for your own particular case. You should see a lawyer if you want one. So this is just for education. But, there is some case law out there where people have been able to successfully file a lawsuit past the 90 days when they can show they did not receive it. They did not receive it in a timely fashion. The EEOC sent it to the wrong address. The mailman never delivered it. What have you. But again, to your point, Winthrop, you shouldn't bank on that because the courts are brutal about this. Yep. If you file on day 91, they're going to say, too bad, you are out of luck. I was in court one time for another case that was before mine that was just, it's heartbreaking to see it, but they were a couple of days outside the 90 days. And this judge, very good judge, very often very sympathetic to employees, I just said, I'm sorry that, the courts are clear. Like I by law do not have jurisdiction now to consider this case because you were outside of the 90 days. So it doesn't matter if your cat died, if you're whatever it is, like the judge is going to say, I'm sorry, I don't even have discretion. I can't even say, right. I'm going to for good cause, which is true in some other deadlines in court, but not for EEOC. You can't say for good cause shown, I'm going to extend the deadline. And also to your point, Winthrop, is do not wait to move on that, because if you're going to try to find a lawyer and look, filing in federal court, I mean, you can do it on your own. Some people do, but if you want to do it with any degree of success, you're going to need a lawyer for that. And if you're on day 89, what are the chances you're going to find a lawyer who's going to be willing to pull together a complaint and sign it and file it in federal court? I mean, slim to none. So it could take, you have to shop around for a lawyer. There are a lot of lawyers who are not willing to, jump into a case like that. You've got to find a plaintiff's lawyer who's willing to take that risk, which can take some time. And it's going to take that lawyer at least a little bit of time to get up to speed on your case, to pull together the complaint, to file it. Now, this is another tip, again, not legal advice. You should have your own attorney, but one thing to consider as an educational matter, if you are up against that 90-day deadline and you need a lawyer, but you have been unable to find one, it is possible, entirely possible, to file a complaint on your own without an attorney in federal court. Because you want to stop that 90-day clock from ticking. And as long as you can file something and get it properly filed, then in federal court, you've got another 90 days now before you have to actually what we call serve the complaint, which starts the machinery going in an actual lawsuit. So once you get it filed, you've actually got another 90-day cushion, which means that an attorney can come along behind you then and file what's called an amended complaint. So it's same with actually filing the charge at the EEOC. Even if you're just kind of shooting in the dark with what you file and you write it on the back of some notebook paper and hand it in, and then you actually get that filed, the attorney can come back and file a nice, pretty, legally sound amended complaint with no problem. So that's something to consider. If you're up against the deadline, you can file what's called pro se. There are a number of things you got to do with that. So again, you don't want to leave it until, if you're on day 85, go down and, this is just like the EEOC office with the phone ringing here. We wanted to have some good atmospherics for you in the background. But, so you want to go down and make friends with the clerk in the courthouse. And again, just like with the personnel at the EEOC, these folks may have power that you don't even understand in terms of who they know and their ability to help you and whether they want to help you or not. Go down, be very polite, make sure that you do what they say, because they can give you some good information about, what you need to do, because there are cover forms. It's not difficult, but there are a lot of different steps to file a complaint. But again, I would recommend, if it were a friend coming to me, I would say do what you can to file it on your own. If you're up against that 90-day deadline, it gives you another 90 days before you really have to do anything on the case, and you've got some time to find an attorney, because that 90-day deadline is no joke.
Right.
Which brings us to, last but not least, the number 10. The 10th mistake is failing to protect statutes of limitations for claims that fall outside of the jurisdiction of the EEOC. So if you were bringing an employment law claim, there may be claims that you have that are not under the jurisdiction of the EEOC. For example, if you are filing let's say you are filing a claim that comes under Title VII of the Civil Rights Act of 1964, let's say it's a sexual harassment case, that is governed by the EEOC, and all the rules that we have talked about are applied. But let's assume that this sexual harassment also involves some touching, and that brings up a claim for assault and battery. Assault and battery claims are state level claims that are not enforced by the EEOC. So if you file a claim you file a charge with the EEOC, it doesn't matter if you put in there all the facts about assault and battery, the unwanted touching. That doesn't do anything to protect those claims in state court, which usually involves filing a complaint in state court. Other examples, there are other federal laws that are not governed by the EEOC. There's Section 1981 claims, which are race claims that can be filed in federal court but don't come under the EEOC jurisdiction. Claims under the Family Medical Leave Act are overtime claims, wage and hour claims, which are governed by the Department of Labor. And again, why this is so confusing and why it's a full employment act for attorneys, although you can file those claims with the Department of Labor, you don't have to file those claims with the Department of Labor. So there may be any number of reasons strategically that you would want to file those claims in direct. In fact, if you came to us, we would recommend that rather than filing with the Department of Labor, because the truth is they're not going to do anything, 99 times out of 100, they're not going to do anything on those claims. So just be aware that the EEOC only has jurisdiction under federal, certain federal claims. Mostly the most that we see are probably under the Americans with Disabilities Act or under, Title VII of the Civil Rights Act of 1964. So again, a good reason to, go get a consult with a lawyer, even if you're not going to hire one, to see if there are other claims that you have that you need to file in state court to protect. For example, workers' compensation claims may be involved, unemployment insurance claims may be involved, that may be very important and lucrative claims for you, but the EEOC is not going to do anything to protect those.
Right, and the reason that's so important is oftentimes those statute of limitations on those claims are longer than the 90 or 300-day period that the EEOC provides, but the EEOC is going to take some time. So you're not going to get the notice of right to sue often before the statute of limitations on those other claims has expired. So you want to make sure that, like Tom's talking about, you make sure you don't miss any of your claims. And they can often arise out of the same set of facts. It's especially true for something like an Americans with Disabilities Act claim that also has some aspect of a Federal Medical Leave Act claim. Those two things, even though the same denial of leave, for instance, for a disability, are the nexus of both of those claims, there are two different laws that are being violated there, and one is protected by the EEOC when you file it, and it's your statute of limitations is protected there, and one is not. So you want to make sure that you do get that consult, or that you do the right research, or whatever you can to make sure that you're not missing anything.
Yeah, no, excellent point. All right, well, I think we have reached the end of our top 10 mistakes people make when dealing with the EEOC. Thanks, Winthrop, for being part of the series, and look forward to having you back on.
Thank you.
Take care.
Yeah.
Oh, I would remind folks that to head on over to our website, www.spigglelaw.com, that we have some very good information for you guys there. If you go to our resources page, we have a case assessment calculator. We have a number of different ebooks that I think folks would find helpful, particularly if you are in the Virginia, Washington, D.C., or Maryland area. Come check us out because we got some good information. And if you want to give us a call, you can certainly do that at 202-449-8527. Thanks so much.
Thank you.